Hello, everybody. I have mentioned the Cornell note-taking method to some students in the past, and some have said that it has really helped them learn how to critically analyze and think through some of the legal questions and problems and hypotheticals, and kind of help them learn how to study. And because of that, and because people have asked me about this method, I thought I would prepare a short video to show how I would use the Cornell note-taking method in this class. So I'm going to go ahead and begin. What is the Cornell note-taking method? Well, first of all, it is something that looks a little bit like this. This is what I have, but if you Google Cornell note-taking method, you'll see all kind of different templates, many of them free. You don't need to pay for anything. I think Amazon even sells a Cornell note-taking notebook where it's already pre-done like this, but you certainly can make your own. I like this one, but certainly it does not have to be like this. Generally, it consists of three main parts. One, the note-taking section, and when you are listening to lectures and you are watching these videos, or if it's an in-person class, if you're taking notes during my class, you would take notes in this section, in the main section there on the right, which is about 2/3 of the page. On the left, you kind of hold that for now. Questions, main ideas, vocabulary, etc. And then the very bottom, you'll see a summary where you can look at that later. Now let's talk about how you would use that in this class. So you start with this, and then let's take the first section, which is courts. So let me make this a little larger so we can read it. And what I would do is just, instead of chapter, I'd put the subject courts, section business 263 for exam 1, your name there at the top, date if you're taking notes on a particular dates, etc. So you're watching the video or you're listening to me in class and you hear me say federal jurisdiction. We're going to learn two different ways of obtaining federal jurisdiction. The first one is diversity of citizenship. And first of all, forgive my handwriting. It's terrible. I know my handwriting is terrible, but I abbreviate things, and I'm just going to tell you kind of what it says. So my lecture says diversity of citizenship requires the plaintiff and the defendants to be citizens of different states. So that's what I have here. I say diversity, plaintiff. That's kind of a paragraph symbol. I've always used it for plaintiff. In the number of years since I've been in law school, I've always used that for plaintiff. You can certainly make whatever abbreviations you want, or you can write it out, plaintiff. And defendant, I always use a triangle for defendant, are citizens of different states, okay? And the amount in controversy must exceed $75,000. And so that's what I write down here in my note, plus amount AMT in controversy exceed $75,000. So that was one of the two ways of obtaining federal court jurisdiction. And the second one, I've got my notes here. Federal question jurisdiction is where there's a federal law, a statute, a U.S. Constitution, a treaty, something like that, that's at issue. And so sure enough, that's what I write down here in my notes. Federal question jurisdiction, JURIS, I abbreviated it, Fed law at issue. I know it's hard to read. Okay, so that's what my note-taking is. I'm taking my notes fast and furious while I am listening to the lecture, whether it's in person or whether it is listening to it online. Then after that, the next thing that I do, and this is usually after class, is I go to the second part, questions, main ideas, vocabulary. And so you think about what you wrote here. The first thing was federal jurisdiction, diversity, citizenship, plaintiff and defendant citizens of different states, and amount of controversy exceeds $75,000. So I write down, what if no federal law required? So no federal law is required for this first one. And I write that down because I've looked at it and I've thought about it and said, okay, there's no federal law required. And then the second one, I looked at it and I said, does this one require a dollar amount minimum? Federal question jurisdiction, federal law at issue? No, it does not. What about different states? No, it does not. So I'm writing down those key elements, things I'm thinking about on what I wrote down on my note taking. Okay, so then maybe that's the first effort at study, and I go back, or maybe you do it at the same time. I'd prefer to do it in 2 different times. I go back, and then at the very bottom of the very bottom, there's a summary. And so I kind of make notes to myself, make sure I know what type, I know my handwriting, I know what type of jurisdiction. Do not confuse them. Only one of them requires 2 things to be met. The other one only requires 1 thing. That's my summary to myself of the notes that I took. So it comes in 3 different parts. The first part being the main notes that you took on federal jurisdiction, diversity, and federal question jurisdiction. The second part being the questions that you ask yourself, or the main ideas. I like to think of it as questions. That's really where I sit there and critically analyze what ifs and what does this mean and that kind of thing. And then the third part being the summary, maybe the hints to myself, the things for me to look at, the focal points, make sure I know what type of jurisdiction I'm dealing with. Because you'll know by now, if you're watching this and after the semester has begun, my questions can require you to think through. Make sure you know what type of jurisdiction you're dealing with. Only one of them requires 2 things to be met. The other one only requires 1 thing. Let me give you a second example. So we're going into the real property, the real estate section, and we're talking about the concept of landlord and tenant. And my lecture discusses the concept of fixtures. And in real estate law, a fixture is something that's affixed to property that you are leasing or renting. And the question is, what happens at the end of the lease? And so you're listening to my lecture, and I say, if you put something on property, if it's put on property you are leasing, you need to know the rule. If permanently affixed, it becomes part of the property. And then I go on and I discuss an exception, because you know the law loves exceptions. There's a different rule or an exception if it's commercial property or business property. If it is capable, if the fixture is capable of being removed without damage to the property, then it's okay for the tenant to do so. So the tenant can take the property back. So that's the first part. You're taking these notes while you are listening to the lecture, either online or in class. So then part 2 comes along. In part 2, we ask these questions. You'll see I have more questions here. What would I put in property I am leasing if it's non-commercial? Well, maybe you put in ceiling fans. I'm just thinking of things. How is this going to apply? I hear the rule, but how is it going to apply? I have to ask myself these questions. I have to think through and analyze when this type of situation might exist. Well, it might be a ceiling fan. I lose it at the end of the lease. If I'm leasing, say, an apartment or a house, and I put in a ceiling fan, or maybe it's cabinets, or maybe it's some built-in bookcase or whatever, I lose it at the end of the lease because that's what the rule is. That's what we discussed. That's the notes that you took over here on the right-hand side. And then I ask myself, but what if it's commercial business property? Can I remove it and still keep it? Yes, if I can remove it without damage. And then I ask myself, what about other fixtures? Well, it's not just a ceiling fan, but, maybe it's a commercial walk-in freezer because it's a restaurant or something. Maybe it's an oven or a stove. Maybe it's a business and I put in built-in desks and cubicles and things like that. Think about other business items. If it can be removed, this is what I say here, if it can be removed without damage, I get to keep it as the tenant. I get to remove it and bring it back with me if it's commercial property. And I've taken these notes here to myself to remind me of that. So then I get to the third part. And really, I recommend doing this in 3 different stages, but you can do it in 2 if you want. It can't really be done in 1. You've got to take the notes, and then you've got to go back and ask those questions. And then the third part is the summary. And this is what I would do in a summary kind of situation here. I would tell myself that different rules apply for homes, apartments, non-business, commercial type property. What might belong to the landlord in one situation belongs to the tenant in another situation, depending on the status of the person renting the property. That means whether he is non-commercial versus commercial, and whether it can be removed without damaging property. I might ask myself in this question over here, well, what if I can remove it without damaging the property? Well, if it's non-commercial, it doesn't matter. I lose it at the end of the lease because I asked myself that question. That's how I would use the Cornell method of critically analyzing and taking notes. If you have any questions about it, there's plenty of stuff on the internet that will probably explain it better than I just did, but I thought it might be helpful if you saw how I would use it in my class with real live stuff that you're studying. Anyway, I hope this helps. As always, let me know if there's anything I can do to help you, and I'll see you on the next Zoom class. Thanks.